Thank you.
You're good? Okay.
All right, in 25 CR 329, State of Texas versus Charles Darrell Johnson Jr. is present with his attorney, Mr. West, and the state's attorney. There's been a change in the defendant's plea. He has decided to plead guilty in the middle of this trial and has entered into a plea agreement with the state. Is that true?
Yes, Your Honor.
All right. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, Your Honor, please.
In summary, Mr. Johnson, as you intimately know, this indictment, which was handed up on March 19th of this year, alleges that on or about November 9th, 2024 in Jefferson County, Texas, you committed the second-degree felony of burglary of a habitation by intentionally and knowingly entering a habitation without the effective consent of the owner with the intent to commit assault. Do you understand what you have been charged with?
Yes, sir.
If convicted, this is a second-degree felony, which means you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand the punishment range that is applicable here?
Yes, sir.
An agreement has been reached where you would be pleading guilty, and whatever sentence shall not exceed a cap of 10 years in prison. So we've got several options. Number one, you could be found guilty, sentenced to no less than 2 nor more than 10 years confinement in prison.
Yes, sir.
You could be placed on deferred or unadjudicated probation for up to 10 years. And a third option is you could be sentenced to no less than 2 nor more than 10 years confinement in prison. And then that could be suspended and you would be placed on regular probation for up to 10 years. Those are your three options. And what is going to happen is the court is going to order a pre-sentence report. We will return back after the probation office. We need to tell them
Yes.
To be alerted. The probation office will go do a pre-sentence report. We will return back on January 5th, 2026. All parties will add anything else you want to include, and the court will make its decision within those parameters. Do you understand the plan? And is that your agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this indictment charging you with the second-degree felony of burglary of a habitation, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? And because you are guilty,
Yes, sir.
show you what's marked as State's Exhibit 1? Did you sign that document?
Yes, sir.
Understand it, discuss it with your attorney?
Yes.
All the contents all true and correct here.
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection, it's submitted. Among other things, this states that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God.
Yes, sir.
State's Exhibit 1 is made a part of the record for all purposes. All right, a pre-sentence report will be ordered, and we will return back on January 5th. And please cooperate with the probation office so that they can get the information they need from you. And I revoked his bond and put him in custody, as you know.
Your Honor, I would.
What do you
like-
want? What are we going to do now?
If the court would allow to reinstate the bond and maybe even add a GPS monitor if you wanted to, so that way he could get number one, assist me on getting everything ready for the hearing. Number two, allow him to take care of all his home issues, because this individual is not in jail like a lot of our clients. He was, out on bond. Let him take care of all this stuff in case he is sent to prison. That's not a possibility. So to prepare for that. Like I said, no contact with the victim. I think he understands now not to have any contact. That's not just physical contact. That's also any kind of electronic, anything like that. But like I said, if the court wants to give him an ankle monitor, so we can monitor. I think we, not me directly, but whoever is in charge of that can monitor, make sure he's not around where he's not supposed to be.
What says the state?
Your Honor, I think that I'd ask that he remain in jail until the time of the sentencing hearing. Obviously, the intended communications to kind of thwart our efforts to prosecute this case. So we're asking that he remain in jail until we have that the sentencing hearing.
Judge, I joined that specifically because I compare this to a situation where an individual is found guilty to an offense and is pending a punishment decision. Your Honor traditionally revokes their bond, we place them in custody. Yes, they can come back and argue for whatever at that stage, but the reality is that all of our evidence was heard already by the defendant before he made this decision. The only thing we have remaining was a 911 call. And so I would ask you to leave it as is. Let's not go searching for this man. Let's make a decision whenever it's reset.
Well, the problem is that I'm whatever I do has to be considered fair for all concerned.
Yes, sir.
And what Mr. Johnson did was clearly, according to the testimony, violate the standard bond condition that everybody is held accountable, all defendants are held accountable for. And not only is this contemptual, where you could be placed in custody for up to 6 months for contempt, but it's also possibly something that the DA's office could bring before a grand jury for attempting to influence a witness, which is a serious offense. The problem I have is that what's good for one is good for all. And I'm reluctant for somebody to say, well, Charles Johnson, he got caught red-handed and you let him out. I want Charles Johnson's rule, please. What's fair is fair. What's fair for one is fair for all. And there is nothing more that really concerns this court more in a trial or in any pending case, but for this surreptitious behind the back door attempts to communicate with people, the victims. That's why we have this strong order. We're not talking about other witnesses. We're talking about don't communicate. It's clear you cannot communicate directly or indirectly with the complainant victim of a pending offense, nor should you go near a residence, school, job site, or other location frequented by the complainant victim. There's a good reason for that. And the court's going to hold him accountable for it. But the pre-sentence report isn't going to take long. We're going to get back here soon enough, and but he's going to be in custody, and we'll bring him back. And how much time are we talking about, generally, for this? 30 days?
It's a little,
Except for January 5th.
so it's like
January
month and a half,
5th.
like 6 weeks.
Yeah. Can we do it anytime? Is there a way we can do it before that?
The only other time we have before that is December the 19th, which is our last docket. Before the holidays, I can talk to probation to see if that's something.
Try to do it
we
then.
can
That's fine with me. I'll be here anyway.
Okay.
Be here every day.
But you're going to be able to, you've got to purge the sin on communicating with her when you were ordered. And that's, I don't want to open this door, and I want to set an example. And I've done that before, is when we catch somebody doing it, they always go to jail. They always go to jail. I mean, how else? It's clear. And if I didn't, then it wouldn't be considered serious, but it is. Because like I say, between contempt and attempting to commit a crime by influencing a witness, I mean, those are two problem fires that have been fought and started. And what's good for one is good for everybody. I don't want you to be able to scamper on out of here and then say what's fair for Charles Johnson is fair for me too. And no, I don't want victims. They got enough problems. They're dealing with enough problems. I don't want them being worried about having to be harassed. And when it's found out that people aren't held accountable, I'm setting a standard. People go to jail for this. They go to jail because it's just the way it should be. This is a clear rule. It's a serious infraction. There's not a doubt about this. So you're going to stay in custody. We're going to get you back on December 19th. Everybody will be heard, and then the decision of this court will be made at that time.
Let's see, get better and stuff. So
Anything else, John, to add? What about the state? All right. That is all. We're in recess.
All right, we'll bring the jury in and release them. Thank you.